your preface and what you said in response to the Deputy Chief Justice.
Paragraph 16.
Yes. Let me just look where the sentence starts. It's a longish sentence. Maybe I should just start from the top.
Oh, yes.
But I could start somewhere closer to where I want to zoom in. It is reasonably believed that to the extent that there is a view out there in the public domain that the loss of approximately 400 lives in the so-called July unrest, which was rightly or wrongly traced by some of the decision of the Constitutional Court to jail Mr. Zuma without the benefit of a trial. I want to skip what's bracketed there. The honorable justices would be naturally and humanly disinclined to find, open quote, anything wrong, close quote. I want to emphasize that. Or even, open quote, slightly defective, close quote, I emphasize that as well. Or, open quote, legally questionable, close quote, I emphasize that too, about the conviction and or sentence. And then you say, and this too is quite crucial, these are the very issues which need to be approached with an open mind. If you say there's the MK party and Mr. Zuma are not challenging the correctness of the conviction, how can whether that conviction was wrong, whether that conviction was slightly defective, whether that conviction was legally questionable, how can those be the very issues which need to be approached with an open mind?
Okay, it's like this, Justice Matlanga. What we're saying, that's why we had to make that distinction up front. What I've said, and that's why it talks about a view out there in the public domain. That view is informed by what I said earlier, that to whatever extent the Electoral Court decision affects negatively, I can't think of a proper word, the decision of this court, particularly on the issue of sentence, of whether the sentence was a sentence for the intended purposes. Now, that view is shared by the MK party and Mr. Zuma, that to some extent the Electoral Court judgment was some kind of vindication of their position that the original sentence and conviction were, to use the words there, quote unquote, questionable. That is a known fact. It's not a secret. Mr. Zuma came here and asked for the rescission of the judgment. So it's not a secret that he finds that judgment questionable. He does. He just failed to convince this court. So there must be no illusion that at any point he ever accepted that judgment as legitimate, that he could be taken, unlike P.W. Botha, he could be taken to jail without a trial. He will never accept that till his last day. But he's not here for that. That's the point I'm making. He's not here. He had to accept, because we all had to explain how the laws of the country work. Once the Constitutional Court has decided, that's it. If the Constitutional Court decides that my name is Mkaitobi, then that's it. There's nothing I can do. So that he understands. The fact that I know that my name is not Mkaitobi is not going to change that just because the Constitutional Court said it. So that's the context in which that submission is made. It is not to say the judgment was wrong, per se. It is to say that judgment was unacceptable, let me put it that way, in their view.
So do you accept that, or you probably don't, but I was just thinking that if you say the conviction was not wrong, would a reasonable person not discount the relevance of all these things, wrong conviction, legally questionable conviction, slightly defective conviction, would a reasonable person not discount those for purposes of what informs the perception?
Yes, thank you, Justice Matlanga. That's an important question. The problem with the question is that it talks about some reasonable person in the omnibus. A reasonable person in his position.
You used subjective exactly at the point where I was close to asking you, aren't you close to making the test subjective?
No, I'm not. I'm not, Justice Matlanga, please. I'm saying that if we are going to take the test of a person in Mr. Zuma, you can't help the cross-pollination between subjective and how do you say a person in the position of Mpofu, but you must take Mpofu out of the equation? It doesn't work like that. It's a question of the reasonableness. But that reasonableness must be tested in the view of that person. In other words, someone else who would have been in that position, how would they feel about the people that they regard as their jailers, so to speak, now having to decide whether that jailing was indeed a conviction for the purposes of Section 47(1). Surely, I mean, all of us should know this. Anybody really in their right mind would have jitters about this. And that's the test. If those jitters, the Pinochet case is a classical example. The Lords in England were at pains, each one of them, particularly I think Lord Craighead, to say, we are not saying that Lord Hoffman is biased. But we are saying, if you look at it from the point of view of Mr. Pinochet, when this judge's wife is a member of Amnesty International that has been campaigning for his jailing, can a person in the position of Mr. Pinochet expect justice? The answer was a resounding no. So the English court passed the test that we are putting to the South African court by saying, no, we can't. We agree that there's nothing wrong. Probably Justice Lord Hoffman was going to find in favor of Mr. Pinochet. But that's not the point. The point is simply whether he could reasonably apprehend. And it was on that basis that the English court found that the Lord Hoffman should not have sat in that matter.
Lastly from me, Mr. Mpofu, and apropos what Judge Pillay did as a commissioner, you and I know that there are countless appeals on the application of the reasonable person test. Let's hope we won't get bogged down by the omnibus and so on. Yeah. But what I want to engage you on is seeing that there will be appeals, and sometimes a lower court's application of the reasonable person test may be overturned by a court of appeals.
Yes.
To what extent must we go by what PLJ did when she chose to recuse herself?
Yes. No. Again, you see, that's with respect, a misapplication of the test, Justice Matlanga. Let's assume, so to make it easy, assume Justice Pillay had no reason to recuse herself. She just was, I don't know, something went wrong with her. Assume that. That's not the question. The question is whether MK and Mr. Zuma, knowing as a fact that Justice Pillay recused herself for the simple reason that she sat here when the matter was for that only reason, whether it's unreasonable for them to expect the 5 or 6 judges that are mentioned to do the same. Surely that cannot be unreasonable. It can be. On what possible basis must he say, no, the reasonable apprehension only attaches to Justice Pillay, but it doesn't attach to Justice Matlanga? On what basis? That would be unreasonable to expect that of a human being.
Thank you, Mr. Mpofu.
Thank you.
No more questions for you, Mr. Mpofu. There are.
Mr. Mpofu, thank you for your submissions. I wanted to test your points about reasonableness in this context.
Right.
And I wanted to put to you a scenario. Let us say a judge, to try and remove it from this context, determines a contractual dispute against an individual. In the course of that, makes certain adverse findings against that person and their behavior, and orders specific performance. The individual does not perform, and the contract is then cancelled, and the person institutes a separate damages claim, which is instituted and comes before the same judge. Should the judge in this case
apprehend, Justice Bilkits, the cases such as Bennett and those kinds of cases that go to, I actually did a recusal application of that nature recently where the judge had shares in one of the companies that were litigating. And it's someone I know, he frankly said, look, my broker buys these shares, but I just had to tell you that I thought there was nothing wrong with it. But when I went to the clients, it was one of the Marikana matters that this judge has shares in Lonmin, or what is called Lonmin, Sibanye now. The client said, by no means can we allow that judge, and as I alluded earlier, I tried to say to them, no, he didn't buy the shares himself, it was his broker, he didn't even know, it's only 225,000 shares or whatever. They said no. Cut a long story short, I moved that application for that judge and he recused himself. Why? Because it was not about him. That's where this problem is really. It's not about the judge. It's about the reasonable apprehension of the litigant. And it was on that basis. And so the answer to your first question is that it would depend on if the litigant was me, who's trained in law and what have you, I might say, well, a judge will come with an open mind, obviously. But even lawyers, we all know how uncomfortable it is to argue an application for leave to appeal before the same judge who found against you. But it's done because it's important. I mean, it would be impractical to get another judge to read the record and so on. So it's done for practical reasons. But anybody who has practiced law knows that that's one of the most uncomfortable things. So why must Mr. Zuma be subjected to that discomfort, which is natural?
Well, it's because of the reason you admit that that is actually not regarded as a ground for recusal, that someone should not hear a leave to appeal, for instance, or a rescission application often would go before the same judge.
No.
You would have, as you said, and there's a double test, of course. It's a reasonable person and also reasonable grounds,
yes,
as well as a presumption of impartiality.
Yes.
that this court has held in Safu and Masuku, etc.
Yes. No, two answers to that. One is that I've said that there would be that discomfort even to a person trained in law, let alone a lay litigant. But as I say, there are things in law we all know that are done for practical purposes. But now imagine this, that after the application for leave to appeal, then the matter goes to the SCA, and you find that same judge sitting there. What would a reasonable litigant do? The reasonable litigant would say, no, you must recuse this judge. Remember, Justice Unterhalter was disqualified because of a simple thing of having sat in the court à quo and also sat in the appeal in the same matter. And that was correct. Not because he did anything wrong, not because he even said he had forgotten or he didn't look and we must believe him. But that was not the point. That's really, if I drive any point home here, it's about understanding that the test is not about the sanctimonious lawyer or judge or whatever. It's about the reasonable litigant in that position.
So the test is not, should it not be about, as you said, if you were sitting in the same matter, but the question is, and I particularly posed that initial question to you, a matter that may be connected to it but is not the same. And in this case, as you've admitted, and I'm not convinced that there's an interpretation of the prior judgment. Ultimately, you said you accept that there was a conviction. There was a conviction. The question is whether that was a conviction for purposes or sentence for purposes of Section 47. And those are two different questions.
Yes.
And there's no need to interpret the prior judgment.
Well, that's a matter for debate. I have no doubt that there's a need to interpret the previous judgment. I'm going to be referring you to many passages in that judgment to reach that conclusion. So there's no doubt about that. But the point is this, Justice Pilkins. If the same judge sits, or let me put it this way, all these questions that you're asking me surely must have played in the mind of Justice Pillay, right? And when they did, she decided that it would be unreasonable and unfair to sit. So we can have a quiz for the whole day about what about this, what about that, what about that. But there's a concrete example of a human being with the same set of facts who felt that it would be unfair, and that's what it's all about, and unjust. This is a court of justice to sit in those circumstances. And this is why really it beats me as to how we can then say a reasonable litigant in the position of the MK party and Mr. Zuma should think that, well, Justice Pillay was just on an off day. No, it can be, as the court please.
Mr. Mpofu.
Yes, Justice Matter.
I know that in your heads and in your papers, you sought to insulate me from my colleagues.
I'm sorry, Justice. I can add you, Justice Matter.
But as you know that this court sits in Bangkok, I want you to assist me because you indicated that I should exercise my conscience.
Yes.
So I want to establish from you what facts or factors must I take into account in exercising that conscience.
Good. Thank you very much, Chair. If you allow me, Justice Matopo, because that has brought back another point that we made, which is related to that question. If you allow me just to make this point before I answer you directly. It is settled law that a recusal is not a collective decision. It's not a group decision. So are we going to recuse ourselves? It is the individual conscience of each judge which must drive them. So it's possible that you, Justice Matopo, even though you didn't sit in that matter, you might say, but I don't feel, my conscience doesn't allow me. It's possible that it could be Justice Madlanga, Justice Chikri, or someone else. So that's the first point to make.
Sorry to interrupt.
I'm sorry, yes.
Would it be possible for me to reach a conclusion that in view of the history of the matter, I may not find myself in a position to sit with all my colleagues?
Yes.
And what would that be that would influence me not to be in that position?
Yes. Thank you, Justice Matopo. Yes, that's another important part of this. It actually, there's a case, I'll find the name of the case, which says that a judge who may recuse themselves, not because of their own conduct, but because they are not prepared to sit with somebody who is compromised, to use a neutral word, or maybe that's too strong, somebody who is tainted by the apprehension of bias. So that's another possibility which you are correctly postulating. In other words, you could not be in the list, but you can say, I, as a judge, cannot sit next to X or Y because of their position. So that's the first thing. But to come directly to your question, Justice Matopo, the factors which would affect somebody in your position would be the following. Yes, this is a highly charged matter. It's been described with all sorts of adjectives, unprecedented, unimitable, and what have you. And to the extent that I was involved in the build-up to the jailing of Mr. Zuma, even though I was not in that particular matter, to the extent that I was part of that build-up, I still feel uncomfortable. We did not include you because we don't think that's a sufficient ground. The mere fact that you were, let's call it Zuma 1, Zuma 2, and this would be Zuma 3, or the rescission would be Zuma 3. The fact that you were in Zuma 1, in our respectful submission, will not involve you having to interpret your own judgment, so to speak. Unlike the other colleagues of yours, or brothers and sisters, it will not involve that. But you're quite right, Justice Matopo. You might say, that notwithstanding, I'm still uncomfortable, A, to sit, or B, to sit with those people who are going to be called upon to perform such a task.
Can we spend some time on this?
Yes.
Because it's a battle of conscience, as you correctly said.
Yeah.
Is it possible, I'm speaking for myself, that I could sit on this application, express reservations, and proceed, assuming the order is, if the order is in your favor, that's the end of the matter. If the order is not in your favor, there is no way that I could recuse myself and still participate in the main matter. Is it correct?
Yes, in fact, that's correct, because that you'll be recusing yourself from the main matter. You remember, Justice Matopo, the law allows anyone, including the judges that had allegedly tainted by bias, to sit in this round, because you always have to do the application to the same judge. But the whole point is to recuse yourself from the main application. You're quite correct. And if I may just add one little thing about the order being in favor or not in favor. That's another red herring. And that red herring can be demonstrated by the fact that we included Justice Theron in the list. Because people are saying, but how could you include Justice Theron if she found in your favor? That's just completely ridiculous, with the greatest respect. Because the point is whether Justice Theron or Justice Shafter was still here. The mischief that we're trying to cure is anybody coming into the matter without an open mind. Whether that open mind is in our favor or against us is irrelevant. The point is that anyone who participated in that decision, for or against, is, in our respectful submission, not capable to approach this matter with an open mind. That's it. It's really simple. And we then peg that against the test of the reasonable, which I've debated with Justice Matla.
All right, let's now get to matters of substance.
Yes.
You have sought to draw an analogy with the matter of former JP Sope.
Correct.
In our correspondence or in our directions, we have given a variety of reasons why it may be perceived that we may not sit in his case. If we take former JP Sope as your reasonable litigant in the same position
Yes.
as the second respondent, Mr. Zuma, would the same concerns that we raised to JP Sope find application in this case?
Thank you, Justice Mastope. That's a very important question. You see, that's really the problem with this thing of looking at this thing from the point of view of a judge. Now, untoward in somebody who was set in a disciplinary process at the JSC. Because he knows, he's trained in law, he's been a judge for decades. So he might not find it, he might not have that apprehension. But to expect a lay litigant to be tested against the standard of justice of JP Sope, former JP Sope, is really to apply the wrong standard. And that is why I said in my answer to the Deputy Chief Justice that the Sope example was brought exactly for that, to say the conditions in that example were much better. Much better. We were dealing with a former judge who understands how these things works. The grounds are, to say the least, feeble, if I may say so. Some of the grounds. I mean, if he came here and said, I want you to recuse yourself because you appeared as counsel for the two justices in the disciplinary, then everyone would ask him to have his head examined. So under those conditions of a litigant who is trained in law, juxtapose that then, Justice Matopo, with somebody who actually, not theoretically, went to jail and sees these people as his jailers, rightly or wrongly, to be expected to then face his jailers, quote unquote, in order for them to interpret whether their jailing of him was indeed a jailing. Really? So
But aren't we now missing the point and straying not really on the application, because now we're just going way beyond what the test is for a recusal. I don't think a reasonable litigant would look at the bench and say, this is the bench that jailed me, and because I was jailed by this bench, I have this apprehension, reasonable otherwise, that I will not get justice if I appear before this bench. I don't think it's the right
No. And that's why I started with that. That is not what the application is about. The application...
I'm saying that against the backdrop of what you've just said.
No.
It doesn't sit very well with me.
No. Well, I'm saying it against the backdrop of where I started. That's why I started there this morning, because I knew that was going to come. That is not the issue of having sat on a bench that jailed him. It doesn't end there. The issue is what the Deputy Chief Justice was asking me and Justice Bilkis as to whether or not this case, this matter, involves or does not involve an interpretation of some sort of that. So I was saying it on the basis of what I've already said. I didn't want to repeat it. But please, if I ever give you the impression that I'm saying merely because these people said in my jailing they cannot sit, no, please believe me. That's the furthest thing from what I'm submitting.
Let's talk about the recusal of Justice Pillay.
Right.
Because you seem to be placing much stock in her recusal at another forum. Mm-hmm. Is that not her own subjective view that if she feels, as you said about my position, that if my conscience tells me that I cannot sit, I don't have to sit, and it does not necessarily mean that my views or otherwise are binding on my colleagues.
Yeah.
So why should Pillay's decision to recuse herself have any bearing at all on this?
Sorry, what is the last? Have any bearing on what?
Why should the recusal of Judge Pillay and the Commission have any link or bearing with our potential recusal or application for a recusal? I'm bringing that in line with what you said about me exercising my own conscience.
Yes.
She exercised her own conscience and came to the conclusion that
Not. I'm not interested in that. The point is that would a reasonable litigant in the position of the MK party and Mr. Zuma believe that the recusal of Justice Pillay is neither here nor there when it is faced with people who are in the exact same position, the Zuma 2 bench, in the exact same position? The answer is a clear no. Thirdly, the position of Justice Pillay is even worse, or better, whichever way you're looking at it, than the position of these judges we're talking about. Remember, as you correctly say, Justice Matoko, as you correctly say, Justice Pillay was sitting somewhere, as you call it here. Now, that's a point against the judges here. Because if she was sitting somewhere, she still felt that it would be unfair to sit in this matter. Much more for the people who are sitting here in this room, in this very room where Mr. Zuma was jailed. So the position of that position of Justice Pillay makes what we're dealing with now here into a Sunday picnic. Because the real issue is that if she could even feel that in some other forum, quote unquote, somewhere, then imagine if she was sitting here, what would she do?
Mr. Mpofu,
Thanks, Justice Machida.
judges often make mistakes, and that is why they are higher courts.
Correct.
And you accept that you make those mistakes, but sometimes in a court with multiple judges, you get outvoted.
Of course.
And that's par for the course. You have to accept the majority judgment.
Yes, Justice Machida.
And when I started practicing mid-1980s in Cape Town, a judge, when I thought I had a bull point and relied on a judgment the judge had given as an acting judge, which was in my favor, said, Mr. Majid, don't remind me of the mistakes of my youth. So we do make those mistakes, but sometimes, even though you are voted, you believe in your case as a minority judgment.
Correct.
So judges must, but even if you still believe you are correct, you are bound by the majority. So judges are able to disabuse themselves from what they thought was the right outcome in their minority judgments so that they follow the precedent of the majority.
Correct.
Now, as I see this case, shorn of all the trimmings, this case is essentially on the merits about two things. Whether a conviction and sentence in section 47(1)(e), what is the meaning of that conviction and sentence if you add the last part, the question of an appeal? That is the first one. Second one, under these parameters.
Thank you. Thank you, Justice Majid. Well, firstly, I'm glad that at least we agree that the case is about interpretation, although you're saying it's about interpretation of the provisions. I accept that. But all I'm saying, I cannot dispute that, as I said to the Deputy Chief Justice. But I'm saying the case goes further than that. And really, anyone who has read these papers will know that the case goes further than that. The case goes to this question, and this is the question that Justice Zondi J.A. answered in the favor of Mr. Zuma and the MK party. Whether, what you correctly say, Justice Majid, whether the conviction or the sentence were indeed compliant with Section 41(7), not in the air, in conditions where that conviction and that sentence was imposed by the Constitutional Court sitting as a court of first instance. We cannot shy away from that. That is the nub of the reason why Zondi J.A. said, no, this does not comply with Section 47. Some ridiculous suggestion has been made in the heads of the other side to say, or even the amici, that what we are saying is that a sentence passed by this court, because it's unappealable, therefore should never apply to Section 47. That's how can we ever say such a thing? If this court was sitting as a court of appeal, as it normally does, then obviously its decision is unappealable. That's not the point. The point is whether, and that's the point that was made by the Electoral Court, when this court was sitting as a court of first and last instance. And who was that? Who was sitting as a court of first and last instance? It's the judges that we've listed in the. So the connection is crystal clear. That if you at least accept that the case is about 47-1, but it goes a little further than that, then it's inescapable that these judges are going to be asked to determine whether what they did to sentence someone sitting as a court of first and last instance was indeed. So that's the first point. The second point, yes, judges make mistakes. By the way, to take advantage, because you made that anecdote, somebody said to me, well, thanks for equalizing the score. And I didn't know what they meant. Now you talk about majorities. And I said, what do you mean? They said, no. Remember, there were 7 judges that found that Mr. Zuma should go to jail, and 2 that found that he should not. Now there are 5 who are saying he should, so it's 7-7. It's a draw. So
I'd never thought of it like that, but I see your point.
Thank you, Justice Machi. So it's these kinds of issues. So if, I mean, I don't believe in that theory, but assume really the matter was on that knife edge. And then what happens? Justice Madlanga, Justice Taron, Justice Mhlanhla, Justice Chikwi, then again tilt the scale against that equilibrium.
I'm sorry to interrupt you, Mr. My judgment was not to the effect that Mr. Zuma should not go to jail.
No. Your judgment was that this is your judgment, Justice, in the first one. I'm not talking about the rescission. The judgment was simply this. If you do not apply, the most abiding thing about your judgment was that if you are going to deny somebody Section 35, their Section 35(3) rights, and if you are going to deny their Section 12 rights, then at the very least you must apply Section 36. And that should be so obvious to anybody. And that is why in your judgment you then went to all the Section 36(1) criteria. You obviously did not, and the second thing you said was that the matter should have been referred to the NDPP. So you're quite right, Justice Taron. Whether after that referral he was going to go to jail, we will never know. So, but the point is that you correctly said, as in the P.W. Porter case, the matter should be tried in the normal way, and it should be. Mr. Zuma is not complaining so much about going to jail. He's been to jail many times. What he's complaining about is being to jail without a trial, without ever standing in front of someone and being asked, are you guilty or not guilty? That's all. So, correction made, but that's exactly what, and Justice Chafta's second judgment went further in the rescission matter, which you agreed with. And it was that not only is this a breach of the Constitution in South Africa, but it's also a breach of the international protocols, particularly Section 9 of the United Nations Charter.
I think you were still busy with the second one.
Yes.
Yeah.
Oh, yes. If you remind me, Justice.
I actually don't know what the second one was. I can't read your mind.
Neither do I. I think your first point was interpretation, which we've dealt with, and then it was the issue about the judges make mistakes. We've dealt with that. The third issue that you raised was the ambit of the exercise before this court, and I think we've also dealt with that.
I just want to test that and that will be my last question. I just want to test what you've just submitted to me. Mm-hmm. And I hear you, but I just want to test that. Mm. One of the things that is raised in the Commission's heads on their written submissions is that the doctrine of stare decisis required the Electoral Court to follow the SCA decision in the, just for ease of reference, the medical parole appeal. You know the case?
Yes, the medical parole case. Yes.
One of the amici there, Institute of Race Relations, put before the court there an argument that Mr. Zuma is not a sentenced offender,
Right.
for certain reasons, and therefore it doesn't qualify for medical parole. The court in its paragraph 24 roundly rejected that.
Yes.
That was one of the parts of the ratio decidendi of the court. So it's binding on the Electoral Court. Now, let's just park that there. What is the difference between a listed judge like me and an unlisted judge? Sounds like the JSE now, but anyway, like an unlisted judge like Judge Sismatopo in deciding that particular point?
No, the role is the same. The only issue is whether you, with respect, Justice Majid, are more likely in the eyes of the litigant to, for example, to cite that as an example that shows that the sentence was a sentence, so to speak, or an unlisted judge. And surely the perception of the reasonable perception of the litigant is that an unlisted judge is more likely to approach that very question that you have posed with a more open mind, because it doesn't really say anything about what they did or did not do. So that's the nub of the issue. Remember that one of the grounds that we raised, by the way, is the fact that, which informs Mr. Zuma's reasonable apprehension for an example, is the fact that that court that you're talking about, Justice Majid, made the finding that a person serving parole is not serving a sentence. And there's this court has said so many times that that is not that cannot be true. And in that case, Justice Mhlahla and Justice Theron were sitting when it came back here, and all Mr. Zuma was saying was, I want leave to appeal on this notion that serving a sentence under parole is not serving a sentence. And this court rejected that. Not rejected whether it's A or B, rejected to even hear it. Just to hear whether or not its own judgment. This is the court that had said, in the case of Pasha versus Minister of Justice, parole is still a manner of serving out one sentence. This very court, you'll find that at paragraph 17 of our heads. It is therefore still a punishment, although a lesser one than imprisonment. It still amounts to a deprivation of liberty for a set period, albeit outside prison. Parolees remain subject to the supervision and authority of the department for the remainder of their sentence. That it mitigates a sentence of imprisonment does not detract from this. The very same court which said that unanimously refused to hear an appeal based on that notion when Mr. Zuma was concerned. So these are issues where it's difficult even for me as his lawyer to explain. When he says, but why won't they at least hear? They might disagree with me in the actual appeal, but surely they must hear it when it's about their own judgment. So all these things play a role, Justice Majid, in the overall perception. Perception is not something you can pick out and say here and that. It's a perception.
Yes, thank you. Thank you, TCJ.
Mr. Hofer, good morning.
Justice Campbell? Sorry.
Your argument this morning is far more refined than that which is set out in the heads of argument.
Well,
and you've asked us to focus on the perception. I'm not sure whether it's a subjective or an objective perception, but the perception of a lay litigant. That's as I understand your argument this morning. Do I have it correct?
No, you don't have it correct. If you're not sure whether it's a subjective or objective, then you don't have it correct. I said the reasonable apprehension of a litigant in the position. So there's no doubt as to whether that's objective or subjective.
Very well. The second respondent is not a lay litigant.
The second.
The second respondent is not a lay litigant. He was the former head of state, and he exercised the powers that that a head of state exercises under Section 83 of the Constitution. That includes the upholding of the Constitution, and it included, in his time, the appointment of judges, both in the High Court and to this court. In that capacity, he would have understood what the oath of office of judges is. And the oath of office is the same whether you're in the High Court or the Constitutional Court. Does that change his perception as a litigant before us because of his knowledge of what judges are supposed to do and how they're supposed to behave?
No, the answer is to the two questions is no and no. One is the fact that you are a head of state or a premier or whatever cannot affect your status as a lay litigant in the sense that when Mr. Zuma was being processed, to put it mildly, by this court, the idea was that he had disobeyed a court order. And that would apply to whether you're a head of state or a sweeper or whatever. It applies to you. The second issue is this. The test of the reasonable litigant is not tested like that. And even if it was, let's say for argument's sake, Justice Campbell, that was the case with Mr. Zuma. What about the MK Party? The MK Party was not a head of state. But it's a litigant in front of you. And the MK Party's perception is that this matter, because remember, it was after all the MK Party that was in front of the Justice Pillay panel. It was not so much Mr. Zuma. So that is a litigant as well. And to suggest that the MK Party was a former head of state would be stretching it a little bit.
And Mr. Mpofu, I specifically referred to the second respondent.
Yes.
Because I understood from the affidavit filed yesterday that the first respondent has distanced itself from the second respondent, and the first respondent has indicated that it will abide the decision of the court. That's why I specifically focused on the second respondent.
Yeah, no, there's no such thing as the first respondent distancing itself. A certain Mr. Jabulano Kumalo, without, as the Deputy Chief Justice explained, without putting any proper papers, has put an affidavit to say that Mr. Zuma's claim to the presidency of the MK Party is false. But you can go through all these papers and show me where do we say Mr. Zuma is the president of MK Party. You won't find it. So what is that going to do with what we're busy with here? That's just an unnecessary distraction and publicity seeking. So let's please not be distracted by that. But assume, for argument's sake, that he's right, and therefore the only litigant in front of you is the MK Party. My answer still holds. So I don't see how on earth it could assist the assessment of this question, even apropos the MK Party only. In fact, it's even worse because against the MK Party, the proposition that you're putting, Justice Campbell, of head of state doesn't apply. So it makes it our case even easier if it's just the MK Party.
Mr. Mpofu?
Yes.
I just want to come in on the Panhla matter.
Yes, Justice Mhlahla.
It's correct that we said that parole is a form of punishment.
Yeah.
But the matter that came before the SCA was a question of whether the medical parole that was granted to Mr. Zuma was appropriately granted in terms of the procedure.
Yes.
And the SCA said it was not.
Yes.
That is the application that came before us.
Yes.
And we dismissed that application.
Yes.
We did not say parole is not a form of punishment. I just want to correct that. You can read the judgment of the SCA from para 54, 55, where it says, while these factors may well be taken into consideration in an application for normal parole, they have no bearing at all in an application for medical parole. So I just want to correct that your statement.
Thank you, Justice Mhlahla. Well, if I may, with your permission, also correct you. Yes, that was the nub of the issue. But that's not why, everyone knows, that's not why Mr. Zuma approached this court. Mr. Zuma, if it was all the niceties about parole and definitions and so on, he probably would have let it go. The reason why he came here was because in that court, at paragraph 60 of that judgment, it says that irrespective of the fact that the 15 months had elapsed, he had to go back to Escort prison and serve the rest of his sentence, irrespective of the fact that that was clearly wrong on the Panhla test. That's why he came here. And fortunately, I drafted the application for a leave to appeal. What I just read out was quoted in that application to say the suggestion that despite having finished the 15 months, Mr. Zuma must go back to serve the remaining 9 months flies against the Panhla theory. And that's what this court said should not apply. And it can be, Justice Mhlahla, that we just choose the other theoretical issues. Yes, whether the thing was lawful or unlawful. By that stage, that was water under the bridge. Because remember, Justice Mhlahla, that by the time those debates were taking place, the proverbial clock had already ticked. I think until it was October, the expiry was October 2022. So the question was a simple one, whether the SCA is correct to send him back to jail. To be honest, if the SCA had done the right thing and said parole is part of serving a sentence, we wouldn't be here. Because Mr. Zuma would have served his 15 months and the 5 years wouldn't have expired, and he wouldn't qualify to be a member of the National Assembly. We are here exactly because, for whatever reason, the SCA found it necessary to depart from the Panhla judgment, and this court also did.
Simple.
Justice.
I can see that you, having what have been on your feet for a long time, but you are seasoned counsel. I know that this is nothing for you.
Thank you, Justice.
Can I take you to, I just need to understand what your problem with us. I'm one of the judges whom your client thinks should recuse themselves from this matter. So I need to understand what is it that you're saying. You said that the fact that we have sat in matters when Mr. Zuma has been there, it's not your case.
No.
But you're saying that on the same breath, as a reasonable litigant, he has a reasonable apprehension of bias that we would then have to interpret that judgment where we then said that he must serve a period of imprisonment. Am I correct so far?
Yes, you are, Justice Chikri.
Is that not the nature of our judicial system, really? Because the nature of our judicial system is such that, for instance, if you're sitting as a judge in the High Court, when an application for leave to appeal is brought to you, the reasonable litigant believes that as a judge, you are going to hear an application for leave to appeal and apply your mind, and if you believe that you were wrong, grant an application for leave. That is part of our judicial system. The same applies to a collegial court like this. Collegial court like this may sit 2 years before a certain judgment, and then another case comes before that collegial court. That collegial court then revisits a matter and says, in that matter, this court did not apply its mind to A, B, C, and D, and therefore add in that regard and change a prior decision. The same applies to rescission applications. And I know because you have brought those rescission applications. You're asking that those very judges, and I'm sure a reasonable litigant like your client would then be going to that judge to say, well, or that court, this court or the full court or full bench or the SCA to say, we're applying for rescission in this matter on these grounds. So why is it that in this matter, us being asked to look at whether the remission by the president interfered with the sentence we imposed, make us biased?
Thank you. Well, firstly, Justice Chikri, I have no problem with you or anyone. And neither does my client and both of my clients. And let me just start at the end of your question. This has nothing to do with the remission point at all. So let's get that clear. This is about the first 2 points, which is the interpretation of what a conviction is and what a sentence is. The remission point is something else. So let's clear that out of the way here. Now, to come to the core of your question, is the question I answered with Justice Machid, that in the answering of those 2 questions as to whether the conviction and the sentence complies with the section, it is inevitable that one of the things you have to do is to interpret that particular judgment which you made and analyze it. We can put whatever word you like. Apropos appealability, apropos the right to silence. I mean, you know, one of the issues we raise is that...
Would you be offended if I...
No, not at all, not at all.
My question really is that not what we
normally
usually do? We normally do. And is that not what is asked of us in ordinary rescission applications and applications for leave to appeal?
No, it's not what you normally do. And that's why I think it was also Justice Machid, or no, it was Justice Bilkis, where I made the distinction between, for example, an application for leave to appeal and having the same judge in the actual appeal. What would a reasonable litigant do in those circumstances? Nobody would even, I once even had a situation like that. It was in my favor, where one of my briefing attorney was an acting judge, and suddenly he was put on the appeal bench. I should have just kept quiet, but I had to bring it to the attention of the judge president that it cannot happen. Why? because that person, they might be the fairest judge ever born in the world, but a reasonable litigant, or my opponent this time, could never be expected to believe that just because the person is now sitting there, when they were the briefing attorney of the other side, they're suddenly going to brief. There might well be. You know, if you allow me, Justice Chick, I don't know why the courts should not be defeated or overtaken by even football associations. You know, if there's going to be a World Cup now, if your country is playing against another country, you are not allowed to be the referee. Why? You might be the best referee in the world, you might be the best, but the reasonable person sitting there in the stands is not, when you give a penalty, is not going to say you're giving it because there's a penalty. They say, oh, you're giving it because you want your country to win. So it's that kind of thing. You know, it's a question of conscience and a question of not comparing apples with oranges, because the situation of the, what you call, application for leave to appeal is a sui generis situation, as I say, which is done for practicality. I'm quite sure that if we had all the judicial resources in the world, we would say, okay, you sat in this matter and someone else will hear the application for leave to appeal. But that could mean someone has to read piles and piles of paper. Plus, Justice Chief, there are safeguards against that. If that judge, and I'm sure some do, decides to defend their judgment and, dig in, it's fine. Why? Because the Section 17 of the Superior Courts Act, where you can petition the SCA, if that doesn't help, then you can come to the Constitutional Court. So you cannot compare a situation of sudden death, to extend the soccer metaphor, to a situation like the one we're facing here. Because the situation of the application for leave to appeal has got so many other safeguards that can make sure that that judge, the subjective digging in of the heels, for lack of a better word, is cured. Here, what's going to happen? What will happen if that happens here? Where do we go?
This is the last question, I assure you. Is this case about us interpreting whether there was a conviction and a sentence, or is it about whether the remission has the effect that
reduces?
Yes.
It's about both, but please, Justice Chief, if you can just work with me here. It's about both of those things. But the recusal, that's the main case. The recusal application has got absolutely, but absolutely nothing to do with the remission point. Please. The recusal application is related. There are three principal points on the merits. Was there a conviction? Was there a sentence? If there was a sentence, was it properly remitted? This application is only about the first two questions. So it's very important this application, nobody is going to say that the judges, simply because they imposed the sentence, are now suddenly going to find a way to say the remission was not a remission. No. All we're saying is, on the conviction point in particular, that conviction, its survival as a conviction, as we know what conviction means in Section 35 of the Constitution. And so you have a conviction that we all know, and this conviction, which must be interpreted here. And that has to be juxtaposed. The second one is the sentence. Whether the sentence, is it even a conviction? And I don't want to now get into the merits, because...
No, I don't want you to get into the merits.
Yes, but please, it's not remission.
I would have thought that a reasonable litigant would be happy that the judges who sat as a court of first and last instance, as you said in your submissions, would then have an opportunity to determine whether, in fact, their conviction and their sentence is actually a conviction and sentence.
Yes.
Because this is what you want us to determine. Because you're asking an apex court to now determine what then happens if a person is convicted and sentenced in an apex court.
Yeah.
What is the effect of that? And I would have thought that you would then have argued for direct access and be happy. And a reasonable litigant would have been happy that those very judges who used faqih and are now faced with the same legal question, but an expanded question on what the effect of it in these circumstances would say.
Yes. Well,
instead of asking for them to recuse themselves.
okay, well, there's a short answer to that one. They are not happy. And the reason they are not happy is because of what you just said now, Justice Chief. You said to determine whether their sentence or their conviction, that's the nub of the issue. Should a judge be
Well, the court sentence.
Yes, no, but I know what you mean.
When we use this lingo loosely, you know
Yes.
that I'm referring to a court's
Yes, no, of course.
conviction and a court's sentence.
Of course. But no, we both know what you mean, Justice Chief. I'm not trying to play with words, but I'm simply saying that that very notion that they have to determine whether their sentence or their conviction now qualifies for this is what causes the unhappiness. And it should cause an unhappiness to any other reasonable person, Justice Sheikh, because it is exactly that point. The human inclination, it might not even be conscious bias, but the human inclination to want to defend, we all have it. The position that you took previously, it's just a human thing. And it is the fear or unhappiness, as you call it, Justice Sheikh, is born exactly of that fact, that the same court, let's not say their sentence, the same court, the same individuals who meted out this conviction and sentence are now going to be called upon. How can a litigant be happy about that? Be happy that the only possible happiness they could have, and they're very happy to be here, is that there's an opportunity to have this matter determined by this court, but not by yourselves. It must be determined by a bench that the litigant has confidence in. He's not saying, I don't want to be listened to by the Constitutional Court, but they're saying that the particular judges who were party to the so-called conviction and so-called sentence should not sit. That's all.
One last one for now from me, Mr. Mbofu. In chambers, you indicated that you might want to oppose to Mr. Nkaitovi's participation in this application, because as far as you're concerned, they are not before court. Do you want to address that aspect now or in your reply?
Yes. Sorry, I didn't hear the last part.
I was asking if you want to address that now or in your reply.
Well, in my reply to Mr. Nkaitovi, I can't, because he can't. I can't be replying to him if he has not spoken.
The horse would have bolted.
Yes. No, Justice, I don't want to make a big issue out of this. But, you know, we can't litigate like this. I know it's an urgent application and all that, and all of us have been fielding all the directions from the Honorable Deputy Chief Justice. But we served a notice of counter application on, I think, the 3rd of this month. And in it, we said any party wishing to oppose must give us a notice to oppose by such and such a date, I think it was the 5th, and an answer by the 6th. No party did so. You know, a notice of to oppose is the simplest thing for an attorney to do. They can do it in their sleep. Just say, I'm going to oppose. Even if they don't even have to put an answering affidavit. By the way, that's what we did with the amici, if you remember, Deputy Chief Justice. We just filed notices to oppose. And we said we'll argue that matter on their papers. We didn't file any answering affidavit. But that's how litigants are supposed to behave. Because we needed to notify the court and the amici that we are opposing their application. Otherwise, they would have come here in the casual belief that nobody is opposing their applications. And that's exactly what the IEC has done. It ignored the notice. It ignored the injunction to do an answering affidavit. It put some slapdash 2-page thing in their heads, which is wrong, by the way. It's factually incorrect because it says that in the Hlophe matter the list did not include merely appearing, which is just wrong. So, you know, as I said, I don't want to be difficult. I'll leave it with the court. But if the example that is being given there is that there are litigants who can just rock up here and want to address the court when they have not done what you've asked of Mr. Kumalo's representative. Where's the notice? Where's this? Where's that? And then if that's what it is, that's what it is. We'll have to live with it, but it is wrong. We want to register that there's no excuse for not filing a notice to oppose at the minimum. At the bare minimum, since that date till today, and therefore, if the rules are there to be obeyed, then such a party should not be given an audience, because we don't know. We really, if I reply to what?
Is that approach overly technical, though? You yourself has pointed out that it's an urgent application, and I think it may be a bit unfair to compare the commission to Mr. Kumalo. The commission is a party.
Well, that's even worse with respect. If it's a party, then it means it was served with the notice that I'm talking about, unlike Mr. Kumalo. It was served with the counter application, and it ignored it. I mean, Deputy Chief Justice, just imagine this in the High Court. I put an application, nobody opposes it, nobody puts a notice, urgent or not urgent, and then I come to the court and I find that there's a counsel to oppose it. How can the administration of justice work like that? And it's not a technicality. If it was a technicality, then it must be removed from the rules. The obligation to notify parties that you are opposing a matter must be removed because it's just a mere technicality.
Right.
It's not. It's not a technicality. It's part of aude alteram partem. It's the fact that you must know that somebody is going to oppose, so that you can prepare on that basis. It's a very fundamental right. It's part of Section 34 of the Constitution. If we have to go that far.
You have made your point, Simple.
As the court pleases.
Would this not be a good time to take the clear adjournment?
As the court pleases.
All right, we'll take 15 minutes until 12:05.
15 minutes, thank you.
arguments, so what should look at? What does it look at? I also do. This is supplementary.
Pillay. Now, if we examine each of them, the first one, tainted by bias because although legally competently, now legal competence could mean you were correct, or legal competence could mean you acted within the scope of your authority. Either way, the correct position here is that that is your job. You have to sometimes find people guilty of contempt and then sometimes impose a punitive sentence. That is what this court is expected to do. And it cannot be a basis for recusal, even if the litigant who is on the receiving end believes that it is unjust. The mere fact that they believe it is unjust does not make the decision unjust in the eyes of the law. It is a subjective assessment that it is unjust because he is on the receiving end of it. Many clients who lose cases before this court believe that the court has done so unjustly, but the court cannot be directed and dictated upon by their subjective beliefs. There is a case that is of some relevance, but it is an English law authority which my learned junior found. It's called JSC Bank versus Ablayazov. It's reported in 2012, EWCA, I think it's a Court of Appeal, page 1551. And what it says that the mere fact that a judge earlier in the same previous case had commented adversely on a party or witness or found the evidence of a party or witness to be unreliable would not, without more, constitute a sustainable objection. And it's directly on point because it was a case where a judge had sent a person to prison for contempt of court, and that person in a subsequent case said that judge must recuse themselves, and they said that's not a basis for recusal. But we don't need to go to England, because S versus Basson, a judgment of the Constitutional Court, says in the course of a criminal trial, there are many adverse rulings that are given against a particular accused. At the end of the trial, that is not a basis to say there should be a recusal. And Basson is at paragraph 42. So that takes care of the first reason. The fact that you are bound to interpret your own previous decision, our view is similar to Justice Piltry's. We don't see this case as an interpretation of the contempt finding. We see this case as an interpretation squarely of section 47(1)(e). But even if it were, it would not be a basis for recusal, because every time a judge approaches a new case, they are informed by precedent. In fact, you, as the justices of the Constitutional Court, are the best placed group of people to interpret your own judgments. And then we go finally to the Justice Pillay example. It is not relevant to what you have to do, because you don't have to follow the subjective decisions of Justice Pillay. It is not binding on you. You are required to apply the law on recusal, which you are familiar with because you decided Sarfu, you decided Sakau, and most recently you decided Masuku. So in summary, there is no basis for the recusal. You should dismiss it. Thank you, Deputy Chief Justice.
Thank you, Mr. Ngocho. Any questions for him, colleagues? No.
Thank you, Madam.
Thank you. A reply, Mr.
Yes, thank you, Deputy Chief Justice. Well, there's nothing much to reply to.
Let's just give them a moment to set the time. It's on.
I thought it was giving me 1 second. Thank you. Thank you very much, Deputy Chief Justice. There's really not much to respond to, because the address by Mr. Nkaitobi is really misses the point even more than what we thought earlier. Well, in his submissions, he said there was one ground for the recusal application. Now he says there are 3. So we'll take the second answer, the one he gives now, and deal with those 3. when we said unjustly, although legally competently, we did not mean what Mr. Mukaitobi says we meant, that the judgment was correct. I was at pains to point out, and this court knows very well, that Mr. Zuma in particular challenged that decision until there was no further room to challenge it. And the fact that it's, when we say that it's legally competent, we meant that it's final, that we accept as a matter of law, not that it's correct in that sense, legally competently. But the important part is the first part where the litigants say it was unjustly so. The second point about the MK party did not exist at the time of the alleged infraction or bias is just a non-point, because it doesn't matter if a judge pronounces on something 100 years ago, before I was even born, it cannot stop me from saying that there is a view, a predisposal to a particular view by that particular judge. So it's not time bound. Similarly, if the litigant was not yet formed at a particular time, and it goes back, maybe kill two birds with one stone, it goes back to the Pillay J point. Despite the fact that I've already said, remember when Pillay J recused herself, the only party before her was the MK party, right? So it did not deter her, the fact that the MK party did not exist before that particular date. She still felt, as she correctly did, that to the extent that the matter also involves the candidacy of Mr. Zuma, and to the extent that that challenge to the candidacy was based on the judgment that she gave, her conscience would not allow her to sit in that matter. That's all. So it's not about the existence or non-existence. Then the other point about losing cases, I mean, I don't know if I really have to respond to that. Mr. Zuma lost the case of so-called Zuma 1 here, and lost the case of the rescission. He's not invoking those. If it was just about losing cases, then he should be saying, well, this judge has made me to lose Zuma 1 and Zuma 3 and so on. He's not saying that. He's deliberately honing in on the contempt of court judgment for the reasons that I was debating with Justice Matopo, as to why, for example, Justice Matopo is not one of the listed judges. So that's really not a point that is worth any response. As versus Basson, there are two things. Mr. Ngatobi says that it says that a judge cannot without more, simply because they have made rulings in the course of a criminal trial, recuse himself. Obviously, that is true. And the two reasons is that without more is exactly what is missing here. We have said the whole morning what is more and peculiar about this particular case. But also, Mr. Ngatobi's own words are contradicting him, because he says, as Basson was talking about something that would have happened in the course of a trial. That's exactly the point we're making here. That the trial, and the point I was making with Justice Chick, the trial is, because of Section 35, has inbuilt protections to make sure that any unfairness or whatever could have been overlooked will be corrected along the way. As Justice Machit says, judges make mistakes, and those mistakes might or might not involve having deep-seated subjective views about this or the other issue. But the system has got a way of dealing with that. Here we're dealing with a different situation where there is no further court. It's not any trial And that's why we don't have trials in this court. A trial, by definition, means that you have another opportunity to correct the issues. I think there's one more issue.
You are way past your 5 minutes, Mr. Mbofu. I thought you were going to finish the point you were making when the bell went off.
I'm happy to do that, Deputy Chief Justice. I mean, there's nothing really much to...
Thank you. Any questions, colleagues? No. All right, thank you, Mr. Mbofu.
Thank you very much, Deputy.
The court will take time to consider your submissions. We can't say exactly how long that will take, but it should not be all that long, so please don't go far.
Thank you.
You will be called once you are ready to come and give our ruling.
Thank you, District.
We need this for the future.
Is there a future?
Rather do it yourself.
Yes.
At least
And if they don't, you'll take me to that. I don't understand. Jason? If they don't